Hello everyone, I'm Nazarat Fatima. Welcome to Live Law. In law, anticipatory bail is granted to a person who claims to be innocent and is apprehending arrest by police. Arresting a person without any valid reasons affects the personal liberty guaranteed by our Constitution. Such people move or approach the court under sections 438 of CRPC, and the court, after looking into the police allegations, feels that a person is prima facie not involved in the offence alleged, and it will give a protective order granting him bail straight away in case of an arrest. But is this right available to a person who is declared as a proclaimed offender? A proclaimed offender is a person who evades the court procedure. Normally, the criminal courts will issue summons for appearance, and even after proceeding to summons, if a person is not appearing, the court will issue warrant of arrest against the person. If there is no response, the court will declare him as proclaimed offender under Section 82 of the Criminal Procedure Code. Can a person who has been declared as a proclaimed offender seek anticipatory bail from the court? That was the question dealt by the Supreme Court in a recent case, which is known as State of Haryana versus Dharamraj. In this case, the person was accused of offences of rioting with a deadly weapon and kidnapping with an intention to commit murder. He approached first the Chandigarh High Court, and the High Court granted him anticipatory bail. This was challenged by the State of Haryana before the Supreme Court. The Supreme Court bench, consisting of Justice Ehsanuddin Amanullah and Justice S.V.N. Bhati, heard this matter and delivered the judgment. The court observed, and I quote, "The respondent, without first successfully assailing the order declaring him as a proclaimed offender, could not have proceeded to seek anticipatory bail. Looking to the factual prism, we are clear that the respondent's application under Section 438 of the CRPC should not have been entertained, as he was a proclaimed offender." The judgment says that, of course, in exceptional and rare cases, the court can even grant anticipatory bail to a proclaimed offender, but that always depends on the gravity of the offences alleged and not serious cases. In this case, the court said, since the offences, particularly Section 64 of the Indian Penal Code, carries a term of imprisonment for life or rigorous imprisonment of 10 years and fine, the High Court should not have granted a pre-arrest bail. Thereafter, the Supreme Court set aside the order of the Chandigarh High Court, which means a person has to surrender before the court and seek a regular bail. The judgment reads, and I quote, "We are cognizant that liberty is not to be interfered with easily, more so when an order of pre-arrest bail already stands granted by the High Court. Yet, much like bail, the grant of anticipatory bail is to be exercised with judicial discretion." To support the said observations, the court also relied upon the decisions passed in Lavesh versus State and Madhya Pradesh versus Pradeep Sharma, wherein the apex court was categorically against the grant of anticipatory bail to a proclaimed offender. This was a brief summary of the case. To learn more about it, visit the link given in the description box, or just go to our website, which is www.livelaw.in. That's all for now. We hope you like our content. If you do, please like and share our videos. Also, subscribe to our channel on YouTube, and don't forget to press the bell icon for notifications. Thank you for watching.